I believe that you're going to begin the argument. You've got 10 minutes, Mr. Gilbert. You have 20, and you've reserved 5 for rebuttal. Okay, please proceed when you're ready.
Court, Patrick Robin, General Counsel to the Governor, Tim Pawlenty. I'll be taking 10 minutes to address the factual context of this important matter this morning. The Solicitor General will be focusing on the legal claims in the appellant's remaining time.
Counsel, I believe that the facts are fairly clear. I have a question that I'm going to ask all counsel, and I'd like your view on it. First, is the unallotment statute a delegation of legislative appropriation authority, or is it merely a codification of procedures for the exercise of the executive's spending authority? Is it a delegation or is it a codification?
Well, I believe it would be a delegation of authority.
Thank you. And if it is a delegation of authority, what standards govern its exercise other than the timing standards?
Other than the timing standards, the standard with respect to delegation is set forth particularly in the Anderson case and the Levy-Delmont. The Anderson case, which we've cited, talks about how in instances in which administrative complexity renders it impossible to set forth a comprehensive, discrete standard, that you have to give a large amount of flexibility to the executive to implement the authority that's been delegated. In this case, we're talking about the authority to spend funds, and the authority is there because the legislature recognized that there is an overarching constitutional obligation to keep a balanced budget.
And what is the obligation of the executive branch to carry out the intent of the legislature once the legislature has passed a statute and the governor has signed it into law? What is the governor's obligation to carry out legislative intent?
Well, the governor's obligation is to see that the laws are faithfully executed. And in this case, the governor has to balance the fact that we have appropriations far in excess of the state's ability to spend.
Counsel, I want to focus a little bit more as to, I'm not quite sure if the governor's obligation is to carry out the law. But a number of cases, and you're probably familiar with them, indicated is the legislative function under our three-branch system of government to determine which policies, which social policies are worthy of pursuit and which are to have priority. And would you agree then that it is the legislature that determines what policies, what social policies are worthy of pursuit, and it is the legislature's obligation under the Constitution to set the priorities, and once those priorities are set by an appropriation becoming law, it is then the governor's obligation to carry out those pursuits and priorities as established by the legislature?
In this specific manner, the governor is having to balance priorities. As the New England case, I think, probably best describes, every bill that is passed...
Wait now. You say it is the governor gets to balance priorities, so then you're saying that the governor can change priorities?
I'm saying that in this unique instance, the governor also has the obligation to see that the Constitution is complied with respect to the balanced budget requirement.
I'm not, that's in the Constitution. The budget has to be balanced. My question is more specific than that. When the governor, if he has this authority, does he have an obligation to balance the budget, to prevent the deficit, to do so within the context of the policies established by the legislature?
I'm not sure I'm fully tracking the question, Your Honor.
Well, it goes back to that basic thing. policies that are determined, social policies, other policies that are worthy of pursuit, and the priority for those policies gets set by the legislature. Do you disagree or agree with that?
They do set a priority, assuming the money is available.
Then the question really is, does the governor, when the governor sees that the law gets executed, have an absolute obligation to follow those priorities when he is determining to balance the budget so there's no deficit?
Well, he also has he can't spend money we don't have.
That's not my question. We've already got that premise established. He's balancing the budget. It's just how he does it.
Right.
And does he follow the legislative priorities?
And the legislative priority reflected in 16A.152 is that the governor is empowered to reduce allotments in order to bring spending with.
Counsel, let me interject right there. It seems to me, in the main, this is a statutory construction issue for the court, and I'm interested in your view of subdivision 4 entitled reduction. It seems to me that 4A and B are the operative paragraphs, and both of them are predicated on the commissioner making certain determinations. I don't see that the governor is deciding under A or B whether to allot or unallot. It's the commissioner that makes that decision, correct?
That's right. The commissioner makes the determination whether the conditions exist.
And that's subject to consultation from the governor and the legislative commission. Now, the question I have for you is, if we look at those two paragraphs, do we have then an issue of how much deference we give to the commissioner in making the determination of whether or not the revenues are going to be less than the proposed expenditures, and if there is that deference, is it a rational basis standard of review or not?
Yes, I believe it would be, and we've cited the Miller v. Foley case, that we're not going to second guess the determination of the commissioner of M&B. And in this case,
let me take it a step further. The argument from the other side is, look, we all knew that the revenues were going to be less than. Even if we look as of July 1, when the decision was implemented, what is the rational basis for concluding that the reduction in revenues was unanticipated?
Well, the statute sets forth the criteria, the conditions that must exist. The commissioner determined that probable receipts would be less than anticipated, and he started.
Well, is it then your view that the economics deteriorated between February and July to the point that there was an unanticipated additional reduction, and that is, in fact, the basis for the decision?
That is exactly a basis.
Well, then, counsel, how come the deficit projected was $2.7 billion in February, and that's the figure that the commissioner used in June? I don't see a difference between the anticipated budget figure. Granted, there are some changes in the monthly receipts in April and March, but the commissioner used the same deficit figure in June as there was in February. So how is it different? I mean, I know there was this $200 million adjustment. The governor, targeted to two, but they used the same $2.7 billion figure that was there in February.
It's different because when you have the forecast figure, and the last forecast is, in this point, was February 2009, that gives you the information to kind of put together a budget. But what the commissioner is saying is that the unallotment statute is triggered.
You get the November figure, And that helps the governor put together his budget that goes to the legislature. And then you get the February figure, which really is to give the benchmark for the legislature and allows the governor, in this case, to revise his budget. But those are the two times set with very specific reasons for the forecast. And I don't see the difference between February and June. And maybe I just got to give you probably a time to answer that because your time is running out.
What the commissioner says in his June 4th letter is, we have this period where every forecast that comes out indicates that the problem is getting worse, and then we realize that the last forecast was underselling the problem. He's saying that since February, we can see that we are in an economic crisis, that he's saying I can already determine that the news is going to be a lot worse than was forecast in February. We are not getting the monthly receipts. The picture that comes out in November 2009 is going to be a lot worse. And that is what he is saying in terms of comparing the February 2009 and then looking on and saying probable receipts are not going to meet that benchmark.
Counsel, we're going to be a little flexible with the time today because this is a significant case and we have some questions, but it seems to me that the February 2009 revenue forecast was $30.7 billion. In June, Commissioner Hansen was still operating in a $30.7 billion revenue forecast, and the governor's unallotment was intended to match a $30.7 billion revenue figure. I'm right on that, aren't I?
The unallotment was intended to be a down payment on what we knew was going to be a bigger problem.
The unallotment was based, the calculation was based on $30.7 billion in revenue, correct?
The calculation of the actions taken in the summer of 2009 were based on that figure, but the commissioner's June 4th letter is indicating, where he's essentially saying, I know the problem is going to be a lot worse.
But we're not dealing with subsequent unallotments. We're dealing with the unallotment there. And I just want to make sure that I've got the facts right, that the revenue forecast in February is the same as the revenue forecast in May, is the same as the revenue forecast in June, although there was an anticipation that the economy would be declining.
That's right. That's the last comprehensive forecast he had, yeah.
Okay. Thank you. Other questions before we allow him to sit? Thank you, Mr. Roberts.
Thank you, Your Honor.
Mr. Gilbert.
May it please the Court, my name is Alan Gilbert, and I represent the appellants in this matter.
Mr. Gilbert, I'd like to give you the same question, and I'll give it to your opposing counsel, too. Is the unallotment statute a delegation of legislative appropriation authority, or is it a codification of the procedures for the exercise by the executive of his inherent authority over spending?
Your Honor, it is not a legislative delegation of appropriation authority. It is a delegation of authority to unallot for the very purpose of preventing a budget deficit, of preventing a financial crisis in the state of Minnesota for the state and for its respective citizens, and to comply with the constitutional mandate of a balanced biennial budget.
So if I understand your answer, it is that the statute is not a delegation of appropriation authority.
Absolutely not.
Okay.
Counsel, let me ask. The legislative branch has the policy-making role, and the executive has the spending role. Is there anything in this statute which precludes or prevents the executive from encroaching on the legislative authority?
Yes, there is, Your Honor.
And what is that?
There are standards, and we have briefed this extensively. There are standards in the statute as to guide the executive, and specifically, as Justice Deason has referenced, the Commissioner of Management and Budget, with consultation and approval by the Governor and with consultation by the LAC. But
Counsel, let me just stop there. I'm looking at subdivision 1 in terms of the purpose of the statute. It seems to me that isn't the purpose of the statute to establish a cash flow account, a budget reserve account, and a general fund of the state treasury, and to provide the commissioner with authority to manage cash flow deficiencies in the state budget resulting from uneven revenue collection and required expenditures? And here's the key phrase for me, quote, during a fiscal year, close quote.
Yes, that's absolutely correct, Your Honor.
So why wouldn't we limit this statute to say that the authority of the commissioner is limited to do, assuming that he satisfies subdivision 4, that he can do certain things in between legislative sessions, not for the whole biennium. This uses the word during a fiscal year, which seems to me is a specific limitation of a temporal nature that says you can do it, but it's only between legislative sessions to balance during that fiscal year.
Your Honor, that is true, and that's what the commissioner and the governor has done here, is that they have unallotted for all the purposes that I referenced before, to make sure that we comply with the constitutional mandate of a balanced budget, to make sure that we don't have a financial crisis in the state of Minnesota, and that we balance the budget.
Well,
and
Counsel, I think you got a timing problem here. The governor announced in the previous biennium that he was going to unallot. The letter came out on June 14th. I think the unallotment notice to the Legislative Advisory Committee was somewhere around the 16th of June. The amount of allotments were determined in June. It was all done before the next biennium. So you just said in answer to Justice Dietzen, yes, you need to do it in the biennium that is affected, but it appears that everything was done before the 2010-11 biennium.
Well, Your Honor, that's not what I meant if that's what I said, and I don't believe I did say that. What I said is that the allotments took place in the next biennium, and there's no preclusion in the statute. And before we get done, I'd like to go back to the literal words of the statute. I think there's some liberty being taken with those very literal words. But the allotments took effect in that particular biennium. There's nothing in the statute that precludes the commissioner from preparing prior to the start of the biennium. But none of the allotments took effect before the beginning of the biennium, and many of them didn't take effect until the latter fiscal year of the biennium.
Counsel, I just want to get the state's position on the applicability of subdivision 4A.
Yes.
Subdivision 4A relates to reductions in the budget reserve account.
Yes.
And there are restrictions on when the commissioner can reduce the budget reserve account. Is it the state's position that that paragraph is relevant here? As I understand it, we're not talking about the budget reserve account. That was already gone. We're talking about unallotments under paragraph B. What is the state's position about whether the language in paragraph A informs this court's construction of the language in paragraph B?
It does, to the extent it provides the triggers for when unallotment can take place. Subdivision 4A says that when revenues are less than anticipated and there's a budget deficit, then the commissioner shall use the budget reserve account, which is the rainy day fund,
and
which, as you point out,
you read those triggers into B as well?
Oh, absolutely.
Okay.
Absolutely, Your Honor, because the beginning phrase in subdivision 4B is an additional deficit
right.
shall be corrected by unallotment.
Thank you. I'd like to get back to the delegation issue.
Yes.
Because it's important to me. Lee versus Delmont, in many cases, say that the legislature may not delegate purely legislative authority. And I thought I had the case with me, but I don't. But as I recall, it says pure legislative authority is the authority to enact an entire law.
Correct.
One that decides who gets what when, basically, is how it works. I mean, it is a policy judgment that there will be in the appropriation context. This organization will get this much money when, okay? Now, why isn't the unallotment statute, which appears to me to place no limits at all on the executive's ability to second-guess that judgment? Who gets the money, when they get it, and how much they get it? I mean, if you look at what the governor did, he just said, these people don't get any, never. Now, why isn't that pure legislative authority?
Well, it's not, Your Honor. As we've briefed extensively in our initial brief and in our reply brief, there's a critical distinction between the spending power of the executive branch and the purse strings of the legislative branch.
I understand that, but if you expand the executive's authority to modify, in the guise of controlling spending, to modify to the point of eliminating legislative judgments, how is that not a violation of separation of powers?
In this case, let's take this example,
Okay.
Your Honor. This particular case, I'm sure that's what you're referring to. In this case, there was an unallotment that equaled approximately, for the biennium, about 10% of the total MSA grants.
Okay.
And the MSA SD program, which is the subject of this, was eliminated as of November 1. But that represented a small portion of the MSA grants. There was not an appropriation for MSA SD. There was an appropriation for the MSA grants generally.
Well, and I think it seems to me that that really kind of highlights the issue. The governor is going in and making subjective decisions on what programs are more important than other programs. And while I understand, the prohibition on spending to deficit, what authority is there for the executive branch to second-guess the substance of the legislation, to make choices internally? I mean, I could see the governor saying we're going to be 10% short of money this year, I'm cutting everybody 10%. That doesn't seem to me to conflict with legislative policy judgments. But as I understand it, the executive actually went in and said, I'm picking this, I'm not picking this.
Well, Your Honor, and what I understand you saying, if I might be so bold here, is that the only way that an unallotment statute could be constitutional if there's pro rata unallotments.
Or some reason to decide for the executive to discern an intent on the part of the legislature to make something more important than something else. Well, I don't know. That's why you consult with the Legislative Advisory Committee, right?
Yeah, in this case, Your Honor, as I indicated, there was a need to reduce unallotments or allotments initially by $2.5 billion. There's limitations on where you find that kind of money.
Counsel, can I just get a little definition? Mm-hmm. We talk about unallotments, we talk about allotments. We're talking about laws. Allotments are laws passed by the legislature describing what programs will be put in place and how they will be funded, how much money they get.
Just to interject, appropriations do that.
Appropriations.
Yep.
But unallotting is, by definition, not giving full effect to the law passed by the legislature. Correct?
It has the effect of reducing an appropriation through the allotment process.
Right, and we're talking about laws. Appropriations are laws passed by the legislature. And to unallot means that the governor is deciding which laws to not give full effect to. Correct?
The commissioner is deciding how to affect the unallotment statute, which is designed to prevent a budget deficit. So that as Mr. Robin...
But again, I mean, is what I'm saying true, though? The unallotment decision does not give full effect to certain laws passed by the legislature in which the legislature appropriated funds.
In that sense, Your Honor, yes. To the extent there's a reduction in the spending amount that is otherwise reflected in appropriation, that would be correct.
So if it does not give full effect to the law, how is the executive to be guided in that decision-making?
And again, Your Honor, there's a number of limitations on what the commissioner can do, and we've itemized all those.
Well, counsel, why don't you itemize them for me here? That goes back to my original question.
Yes,
I'm still trying to figure out what those standards are.
Okay. Well, Your Honor, initially the standards are restrictions in terms of what the unallotment does. The unallotment does not destroy the underlying appropriation. The underlying appropriation stays in effect. So that in the event that there's additional revenues through the economy or through other appropriation by the legislature, then that appropriation is still there and the monies can be spent for that purpose. Under state law...
Let me just make sure I
Yes.
understand that. So you're saying that if, I mean, let's assume that the decision is made that this program, this diet program, is going to be unallotted, and then hypothesize all of a sudden the state gets a bunch of money that was unexpected. Are you
Correct.
saying then that the diet program could get refunded in effect?
Absolutely.
Does it require additional legislation?
No.
Or would it be by commissioner's order?
It could be just by the commissioner's order, because the funding has been restored. And that's a critical distinction. And there's several other standards like that, Your Honor. But
Restoring, there is no obligation to restore
No,
one
there-
program over another.
there is none. You're absolutely right, Your Honor. And if the funds are not restored, then there's no money to do that with.
Let me give you a simple hypothetical, and I don't want to move too far off the statute in Justice Page's question, but let me just give you a simple hypothetical. We have a budget of $100
Yeah.
for the biennium. The legislature has said we're going to spend a third on schools, a third on roads, and a third on public safety. There's not enough money in, let's just take the timing out of the hypothetical. In the middle of the biennium, we have an emergency, a 9/11 event, and there's only $75 for the biennium. It's the governor's position that the governor has the authority to decide that we're not going to give schools a third anymore. We're only going to give schools 10%.
Your Honor,
And give public safety 100%.
yeah, and I understand.
You think he could do that?
I mean, and that's my question is
I
that
understand.
what this statute would permit a governor to do?
The statute requires discretion on the part of the commissioner, and incidentally the governor, because the governor has to approve what the commissioner does. So in theory, that would be a possibility. Now, I don't know that that has happened here. What has happened here is that the commissioner has decided...
Am I correct that I hear you saying that the governor has unfettered, or the commissioner, whoever, has unfettered discretion?
No, I didn't say unfettered discretion. In theory, the commissioner, in exercising his discretion, he has to operate in good faith, and we've cited the case law with respect to that. The governor, in approving, has to take due care to faithfully execute the laws.
Where are the limits of that discretion?
The limits of that discretion are within the Constitution and within this case law of this court.
Where are they in the Constitution? I'll have the Constitution
where
here.
the governor-
No, I want chapter and verse in the Constitution exactly where they are.
The governor has to faithfully execute the laws. I believe that's Article 3, Section 1, I believe. Well, let me look here, Your Honor.
Article 5, Section 3, I believe.
Article 5, Section 3. Article 3, Section 1 is something else.
And the
and in
specific
terms of-
language that you are referring to?
Yes.
No, I want the language.
Okay. Yeah,
I mean,
I
this
don't-
is important. This is.
The language is to that effect, that the governor must faithfully execute the laws of the state of Minnesota. And that's what's in the Constitution. So the governor has to use that as a guideline when he decides whether to approve or not approve the commissioner's unallotments. And the commissioner...
How do we determine...
There's two
whether-
ways. I understand the question. There's two ways, Your Honor. And one thing Mr. Robin didn't get a chance to talk about is the political aspect of this matter, the political dispute that is going on between the legislature and the governor. And there's two ways that a political dispute could get resolved. One way does not involve the court, because it involves a political question. We briefed that here, and it clearly involves a political question. But it's the electorate that decides, in the sense that our system of democracy has in mind that if they don't like what the governor is doing, or if they don't like what legislators are doing, they either approve or disapprove those actions at the next election.
I appreciate that, Mr. Gilbert, but we're here to decide whether the unallotment was appropriately undertaken.
Yeah.
And that is a question that we have to decide. It is not a political question. It is whether either the statute or the Constitution allows the governor to do what he did here. And so, that really is the question that we have to answer.
And I agree with you, Your Honor. The court certainly has the authority to decide were the terms of the statute complied with, and secondly, is that constitutional? In terms of the constitutional issue, below, there was no challenge to the face.
That's because they thought they were bound by
Well,
Rukavina.
okay, but Your Honor, I just want you to know that that's the status of this particular dispute.
Go back to the timing question, but not the timing question the district court was concerned about, but rather the language that talks about the biennium. In 1984, the legislature removed the words "discovered any time" and changed it simply to "determine." Does that tend to strengthen respondents' argument that when you unallot on the very first day of the biennium that that's not the remainder, and if not, why not? Now, I acknowledge, and I'm going to ask counsel your hypothetical, that it raises the possibility of an absurd result, that it is inappropriate or non-statutory on July 1, but is acceptable on July 2, and I'll be interested to hear what their response is. But independent of that, what's wrong with that argument?
What is wrong with that argument is the literal definition of remainder. And we have cited to just an ordinary dictionary definition that says whatever remains or is left of the period in question. In this case, all of it remains. And therefore, the remainder, the phrase in the statute is totally consistent with the facts of this case.
Counsel, just run that by me again.
Whatever.
No, I just want to see, you're saying that remainder can be the whole?
Absolutely. And that is based upon...
And now I want you to say, according to the standard definitions, I'd like to have you, I mean, I've looked at some definitions and I find a hard time finding, because they generally refer to something left after other parts have been taken away. The part, you know, is it, I mean, even taking it from mathematics.
That's what I want.
There is, you know, something taken away.
Well, Your Honor,
so how can it be the whole when a standard definition of remainder is what's left after something is taken away? Because if there's the whole, nothing's been taken away.
Your Honor, we cited to an ordinary dictionary definition in our brief, which says just what I indicated, that the definition of remainder is whatever is left or remains. And in terms of a mathematical analogy, I think that is right on point. If you have the number 1 and you subtract a 0 from it, because no part of the biennium has elapsed, you still have 1. Counsel, and under math, 1 minus 0, the remainder's 1.
Counsel, let me ask my question before your time expires, and that is this. Can the court consider the practical limitations of the governor's unallotment, or I should say the commissioner, we keep saying governor, but the commissioner's unallotment authority? And by that I mean the governor and the commissioner unallot, and then the legislature's back in session. The legislature has the authority, they haven't delegated that, to unallot, or to undo the unallotment. And they can say, we disagree with what the governor did and what we need to do here, and they can undo the unallotment, correct?
Absolutely. And that's what I understand to be the rationale of the commissioner, to unallot the initial $2.5 billion. This goes to your question, Chief Justice. To unallot the first $2.5 billion and await the November forecast to quantify the amount of revenue that's going to be less than anticipated in the February forecast. And as well await the legislative session, which is precisely what is happening right now. So yes, Your Honor, and a couple of points I haven't had a chance to respond to, but we rely heavily on the New England case, and I'm sure you're aware of it. I really encourage you to read the New England case.
I've read it several times,
okay.
Counsel. There are a dozen or more informative cases around the country.
Can I, may I ask?
Your Honor, but this one is consistent with the Lee versus Delmont and his progeny. And the approach that this court has taken to legislative delegation for the last 60 years.
Justice Gilday would like to ask.
Counsel, I just wonder about the state's position on, you were talking about the political nature of this dispute. Is the state asking us to rely on any principles of comity, and by comity I mean C-O-M-I-T-Y,
yes.
In this context?
No, Your Honor. We're just asking that the court exercise its authority, and it does not have authority to decide whether the governor was correct or the legislature was correct in this political dispute. And what has happened here, and again, I go into this with the preface that I don't think it's relevant, nor is it within your jurisdiction. But the other side relies very, very heavily on what the governor did when he signed the appropriation bills. There's no discussion of the legislature sending the appropriation bills after the governor vetoed the revenue bill. And I'm not assigning fault to anybody. What I'm suggesting, and what I think we've tried to articulate in our brief, is that that's a political arena. There's a political dispute. We're dealing here, as you recognize, Chief Justice, with the aftermath of it. And the question is, what do we do with the aftermath? And I suggested to you that the electorate is in a position to decide what to do with respect to the political decisions that have been made. In terms of a legal principle, Your Honor, I think this is what you're getting at. What remedies might be available to someone if they think the governor and the commissioner have gone too far? Well, there's always an equal protection claim. And in fact, you see in our materials that there was a case in the early 1980s brought in Ramsey County District Court challenging unallotments of Governor Quee.
Well,
and there was an equal protection claim litigated in that case.
In addition to an equal protection claim, though, counsel, there isn't it available to say simply that the governor has not complied with the obligation that he has under the statute once a law is signed into law to give his best effort and good faith effort to give effect to that law?
In terms of whether there's a rational basis, yes. Yeah, Your Honor, in terms of...
That would be the argument.
Yes, I agree. There'd be an argument to that effect. But when you're dealing with a political dispute, I would submit to you, with our system of democracy, it's really the electorate to decide that. But at the same time, there are other principles, such as equal protection, that can be invoked.
Well, I understand that, counsel, and I understand intellectually your point about this being, in some level a political dispute, but I have to say that doesn't concern me, and I can't speak for my colleagues. I'm trying to figure out what the Constitution requires.
Your Honor, and I'm sorry, I agree completely. That is certainly the role of the court, to decide whether the statute is constitutional on its face. There is no as-applied constitutional violation in this context. So we ask you to look at it on its face. We, again, rely heavily on the New England case as well as other cases. And we distinguish the other cases that I think you might have referred to, Your Honor, that we just don't think of application. But I would really caution the court, in light of the history of the legislative delegation doctrine in the state, since the Lee versus Delmont case was decided, there's only been one case that has been decided where the legislative delegation is unconstitutional, and that didn't deal with the standards. It dealt with delegation
and that case
to a private
was,
party.
And that case was which?
Your Honor, I don't recall the name of it because it dealt with a private party. It has no relevance here.
Counsel, I just want to make sure I understood what you said. Is it the state's position on this question, which some of my colleagues are asking you about whether the commissioner faithfully executed the laws? Is it the state's position that we would review that for arbitrary and capriciousness? I mean, it's an administrative law sort of context. Is that that's what your argument is?
No, Your Honor, it's really not. Again, my position is for the electorate in the first instance.
I get that, but
secondly, there's an equal protection basis. If someone feels...
Right, but I thought you said in answer to... I'm sorry to interrupt you, but I thought what you said in answer to one of the Chief's recent questions was that the question about whether the executive properly gave effect to appropriations would be reviewed for arbitrary and capriciousness.
Your Honor, no, not necessarily. What you would review, as I think has been mentioned by a couple of the justices, is whether there was a rational basis for the determinations that triggered the statute.
Okay.
But
and
not
how is
necessarily.
That different from...
But in effect, if there's an equal protection claim, the basis for review is rational basis.
Okay.
So in effect, you'd be doing the same thing.
Okay.
Counsel, you've indicated you rely very heavily on New England. When you come back for rebuttal, is the New England case you refer to as from 2002, but it relied very heavily on the case of opinion of the justices in the same court of Massachusetts in 1978. So when you come back, would you please be prepared to explain the juxtaposition, because and I'll give you my view, is
Yes.
the opinion of the justices in 1978 really provides the template and the informative structure for New England, and I'd like to.
And it does.
Yeah, okay, but anyways, I'm not going to take any more time
Okay.
now, but when you come back, if you'd be prepared to address
Okay,
that.
thank you, Your Honor.
Thank you, Mr. Gilbert. Mr. Robinson.
Chief Justice, members of the court, my name is Galen Robinson, and I'm here representing Deanna Brayton, Ms. Bernhagen, Mahabedi, Bullock, Griffin, and others in this case. And
Mr.
this case
Robinson,
is about them.
Mr. Robinson, let me ask you the question that I've asked your two colleagues. Is, in your view, the unallotment statute a delegation of legislative appropriation authority, or is it merely a codification of procedures for exercise by the executive of the executive's inherent spending authority?
Our position that it's a delegation of authority.
Counsel, can I just want to make sure I understand. The Florida case, which you rely on heavily, Childs, discusses the two different strains of separation of powers inquiry. And it says there's the encroachment strain and the non-delegation strain. Do I understand you to be saying this case is about the non-delegation strain of separation of powers inquiry?
This case is about both strains, Your Honor. It's a delegation of authority, and to the extent that the statute did not authorize the commissioner to make the determinations he did, it's an encroachment upon the legislative's power.
Counsel, what authority is there, if any, for the executive branch to spend into deficit because they're presented with an unbalanced budget for whatever reason? I mean, you know, we've heard Mr. Gilbert talk about the political process. You know, it doesn't much matter why, at the end of the day, there was a structurally imbalanced budget. And what authority does the governor have to spend into deficit?
Your Honor, under the Constitution, the budget must balance at the end of the biennium.
So you think that you can overdraw the checking account all the way up until the end and then figure out how to fix it?
I don't think that would be prudent. But the Constitution envisions that. The Constitution envisions that the laws are passed by the legislature. They're presented to the governor, who can veto them, use a line item veto on appropriations, or pass them. Once they're passed, it's the duty of the governor, as you've all noted, to faithfully execute that law.
But he doesn't have enough money to do it then.
To the extent that the governor signed the appropriation bills into law knowing that there was going to be a deficit, the Constitution also provides a solution. We're not suggesting it's for the court or anyone to tell the governor what that solution is, but the Constitution provides a solution for the two branches to reach a balanced budget in the first place.
Well, there are actually three solutions. There is call a special session and get it worked out.
That's correct.
Shut down the government when you run out of money. But isn't there also a third option, and that is just don't spend as much as the appropriations called for, as long as you try to give effect to the intent of the legislature? Isn't that a third reasonable alternative?
It would be a reasonable alternative if the statute provided for that, but the statute doesn't provide for that.
So you would take the position then that the Chief's earlier hypothetical of a proportional cut in all budgets, that doesn't save the unallotment here either, so that would also be unconstitutional?
Your Honor, under Lee versus Delmont, there has to be clear policies and standards of guidance.
But I think Barry
it has
Anderson
those.
said there's a clear policy, just unallot proportionally. That, you can't be much clearer than that. So could the legislature have a statute that says, Governor, just unallot proportionally, with the exception of don't touch the legislature, don't touch the judiciary, and don't touch workers' comp, but otherwise do it proportionally? Would that pass constitutional muster?
Your Honor, there are different states that have looked at that and considered that, and that might pass constitutional muster, but here we have a statute that requires two things, and I think we've all talked about that the first one never occurred. Receipts were never less than anticipated.
Okay, but now you're talking timing. We want to talk about delegation, and we want to talk about clear standards. There isn't any standard in this statute, is there? It simply
There
says
isn't,
it
Your
may
Honor.
unallow.
Well, Counsel, I
I
just have to take issue with that, because I think that there are standards in the statute. The standards are set forth in paragraphs C, D, and E. The standards are also set forth in other provisions the legislature has passed, which say thou shalt not unallot from X, Y, and Z. And unlike the Alaska statute, there also is a limit on what the executive branch can unallot, in the sense that you can only unallot to fix the deficit. The problem in the Alaska case was that there was no back end. The door never shut on the executive in the Alaska case. Here, there's a beginning point, there's an end point, and there are standards. Now, you would say they're not strict enough standards, but there are standards in the statute to guide the executive's exercise of discretion. And I would suggest to you that there are certainly enough standards here to meet this court's case law, particularly the Anderson case, where we talked about habitual violator. And we said there's enough here for the executive branch to understand what habitual violator means. And so under our case law, why aren't the standards in the statute sufficient to pass constitutional muster?
Standards aren't sufficient to pass constitutional muster because here we're dealing with pure legislative power. We're not talking about an administrative decision to interpret a statute, but we're talking about the power to make a law complete.
Well, let me just push back with you a little bit there. You say pure legislative power, but I think you would agree, wouldn't you, that the authority to spend is the executive's authority?
Your Honor, I agree that the executive has the spending authority, but
Okay,
if you
so
look at
then-
the cases, that's not to spend wastefully. It's
Well,
not to
yeah,
disregard.
right. I mean, I'm just trying to get in the door here. And what I want to suggest to you is that what we're really talking about here is the authority that is within the scope of both branches, both the legislative branch and the executive branch. It strikes me that this is something that both have constitutional responsibility for.
I would agree they do, and the state relies heavily on New England. I think you have to look at New England to see what the limitations are in the spending power.
So
As the
if this
Justice
is
pointed
something,
out-
if this is something that involves both, then, doesn't that by definition mean it is not purely a legislative function?
Now, Your Honor, under the Lee versus Delmont case, pure legislative power is the power to make complete law as to time and place, and that is what the appropriations did. If you look at the New England case and the opinion of the justices to the Senate, which it's premised on, it talks about the spending power, but more importantly, it talks about the governor's duty is to affect the law as it emerges from the legislature. It is, the spending power is still restricted so that the legislative intent is substantially complied with. That did not happen this year.
Well, Counsel, if the purely legislative power is to make a complete law, as I paraphrased it under Lee versus Delmont, it's to decide who gets what when. I heard your colleague say that unallotment only deals with the when, not who and what, because it's, you don't get it now, you get it when we have enough money. Is that enough to make it not a delegation of pure legislative power?
Your Honor, you have to look at the effect of these unallotments. It wasn't simply that we're going to delay them. Our client's special diets were eliminated in November. The legislature doesn't come into session again until February. It completely eliminated those diets. The legislature decided in May, when it passed the Health and Human Services Appropriation Bill, we will fund these programs on the same day. The governor passed that. He had a duty to faithfully execute it, but he announced, however, I'm going to use unallotment. And then in June, he completely eliminated that program. That's the effect of nullifying the law, not simply delaying.
Could the legislature have eliminated this? I mean, could the governor have eliminated this program by line item veto?
No, Your Honor, the governor did not have. The Minnesota Supplemental Assistance Diet was one item in the budget.
Is there a different aspect here is by line on item veto, the governor cannot reduce funding? if it's a matter that's subject to line item veto, he can strike it, it's gone. But the governor with the line item veto power does not have the ability to reduce funding. Is that correct?
That's correct, Your Honor. That would have been an item reduction veto, which this court looked at in interference.
Here he reduced and then eliminated. Is that correct?
He did it in 2 steps, but he did the same thing. He basically eliminated, well, the commissioner made a determination, and then the program was eliminated.
Counsel, let me ask you the same question I asked opposing counsel. Do you agree under subdivision 1 that one of the purposes of the statute is to provide the commissioner with authority to manage cash flow deficiencies in the state budget in order to essentially balance the budget during a fiscal year?
Yes, that is, in essence, 16A talks about how the Department of the Management and Budget manages the budget.
The point is to balance the budget, and if the commissioner determines that the budget is not balanced or imbalance, doesn't the commissioner, assuming that he or she satisfies the criteria under 4A and 4B, have the authority to go after the budget reserves, and if there aren't any budget reserves, to then unallot until the legislature can come back and fix the problem?
Under the statute as written, that is what the commissioner's authority is. However, that's not what happened. We didn't start with a balanced budget. All of the cases involved in this case, other states started with a balanced budget.
If we start with the premise that this is just between the time in which the legislature is in session, aren't most of the unallotments at issue here in the second fiscal year, not the first?
Your Honor, the unallotment of our client's program was in the first fiscal year in November, as was the unallotment of the Emergency General Assistance Program.
Issue, if the budget is not balanced and the commissioner satisfied the criteria in 4A and 4B, now I know you don't agree with that, but if he did, would the commissioner have the authority to reduce and or eliminate that program during the time period July until February to balance the budget?
As we've been talking about, I think the statute doesn't provide clear enough guidance to the commissioner as to how to make the unallotments. The effect would be to completely eliminate a program.
So is it your view that the statute is not constitutional because, well, under your view, the governor has no authority to unallot?
Your Honor, we think the statute can be interpreted in a way that makes it constitutional if it's limited to its plain meaning. Receipts less than anticipated and the amount for the remainder of the biennium are less.
And I asked you to assume those two facts had occurred here, and you said even if that's the case, the governor could not unallot this program during the time period July through until the legislature met again.
I think the key with all of the allotment reductions that are permitted is that they still have to ensure that the legislative intent is complied with. Picking one program over another, choosing which program to eliminate is not sufficient guidance. It doesn't provide any standards to how to do that.
So, boiling it down, your position is the statute is unconstitutional on its face.
If interpreted, the unallotments that have occurred in June of 2009, yes.
Well, tell me how you think it could be saved constitutionally.
Now, originally, this statute was passed. Governor Stassen proposed it in 1938 because he was elected to a budget deficit. And he suggested that the state needed some authority to reduce allotments when revenues decrease. Not because they might decrease, but when they actually decrease. The statute originally talked about the amount of revenue. It was amended in 1984, but not to change the effect of the statute.
All right, I would like to give you my hypothetical, which I gave to the governor's attorney, which is there was a budget passed, there's a $100 budget, the legislature has allocated 1/3 to each of schools, roads, public safety. In the middle of the biennium, there's a disaster, a 9/11 disaster, type disaster. Does the governor have the authority under this statute to unallot funding for schools that we can dedicate more money to public safety?
Your Honor, under that hypothetical, I do not think the statute's constitutional, simply because it is not affecting
But this,
the
do you
legislative
agree that the
intent.
statute would permit the governor to exercise that authority?
Yes, in which case it's not constitutional, Your Honor. The
And
statute-
so your
the
view is that
governor
what makes
has-
it, so if the governor had done a 1% unallotment, then your view is that would have been constitutional?
No, Your Honor, what the governor is supposed to do is to faithfully execute the laws. Those are the laws as they emerge from the legislature. If the legislature is making a policy decision as to we're going to fund these programs, then for the executive to choose to fund some but not others violates the intent of the legislature.
So
and then it would not be constitutional.
But how is it constitutional? So you're saying if it's across the board, pro rata, that's constitutional?
Perhaps that might be.
But
That's
how
not
is
the
this
issue
court
we
to
have
make
here.
that judgment call?
Well, that's part of our, as we briefed this, the statute doesn't provide sufficient policy or guidance. If you look at cases where there was guidance provided, those statutes can be constitutional, very specific. You can even look at a federal case where ultimately it was decided it didn't pass muster because of the person who was exercising the power. This is cited, I think, in the professor's brief. It's the Boischer case. There was a very clear policy as to how reductions were to occur. That would work. Here there's nothing. It simply provides you may unallot.
Well, blue line the statute. What specific language should be in there to pass constitutional muster under this court's jurisprudence, recognizing, as the law professors tell us, that we have never in our state's history struck down a statute as not being sufficient. So blue line statute for me.
You know, best I can do is suggest that the other cases have provided guidance. That would be the guidance we would look at.
Well, but the Vermont case, which you rely on heavily, there was language in that statute that specifically said the executive must give effect to the legislative priorities, whatever those are. In the Alaska case, there's no end point. There is an end point here. I mean, so what are you suggesting? What exact language should there be in the statute?
We would suggest that the Vermont statute, to the extent the legislature chooses to pass it, would work.
But
that
how
statute provided that there were recommendations, but a legislative commission could accept or reject those.
How does that square, how does that blue lining square with Anderson, with our case of Anderson?
Your Honor, I'm sorry, I'm not sure.
Anderson is the habitual violator. That was the standard that the executive branch was given, habitual violator.
The distinction here is power that we're talking about. Here we're talking about an appropriation power.
Right, but you and I have already been through this, and I thought you agreed, maybe you didn't, but I thought you agreed that we're in the middle here. We're in the area where both of the politically elected branches have responsibility.
The responsibility of the executive is limited to the spending power, not to spend wastefully. It does not extend to the legislative power to make policy decisions as to which programs to fund, how much to fund them, and when to fund them. And that's the critical distinction in our mind. The cases that permit the administrative branch to make decisions are all about cases where you're dealing with complex issues, areas where the legislature...
Is this not budget forecasting, state's budget? Is this not a complex area?
This is an issue where the administrative branch has no more expertise than the legislative branch. The legislative branch takes February forecasts, just as the executive does, and bases all of its spending decisions upon those.
But, Counsel, we have we have a commissioner who arguably has the expertise, who has made a determination that the triggers in 4A were met. Why shouldn't this court exercise judicial restraint and defer to that decision if there's a rational basis to supported. And in light of what we said in Lee, isn't this economic forecasting such a complicated area with so many assumptions, coefficients, and variables that would give more deference in this case?
Your Honor, the deference that you're suggesting is not warranted, I think. First of all, it's a case of first impression. Second, we're talking about allotment study, about forecasting or other things. Commissioner has only looked at the statute 4 other times.
We are talking about forecasting to the extent of whether the revenues are going to be unanticipated, whether there's a shortfall that's unanticipated to the extent that something needs to be done to balance the budget, right?
Your Honor, if you look at the Commissioner's June 4th letter, I think you find that it doesn't meet the statutory requirements, and that's one reason not to give deference to that. The letter states that revenues are anticipated not to be sufficient, but it wasn't that they were less than anticipated. It talks about a difference between November 2008 and February 2009 benchmark, but the benchmark that they're using to determine the budget is not the difference between those two, it's the February. It also says that there's not sufficient evidence that the budget outlook will improve. That standard is simply too vague to pass constitutional muster.
But I guess even assuming what, well, I mean, what is true, that there was a shortfall that was projected, but in economic forecasting, it's such a complex field. What I understand the commission to be saying is that there was further variation in the economics, and it seems to me that at one point there was a prediction that we'd have 8% unemployment. Turned out we had 10% unemployment, and real unemployment was 17%. So why don't we give that deference to that decision to the commissioner? We give
the commissioner the authority to create the forecasts, but those forecasts, once created, are the benchmark that the budget is created. The forecast, taking into account all of what you're suggesting, was there were $30.7 billion in anticipated revenue. And in May, that forecast hadn't changed. For the statute to apply, for the commissioner to make a determination that the statute applies, there has to be an amount less than anticipated. If you go back to the original history of the statute as written, and again, it was to be amended in 1984, it talked about the amount that remains. That's a dollar amount, the amount that was anticipated and the amount that remains, not a vague principle that we're in a worse economy. If that standard were sufficient, then the commissioner would be, has no.
Also, can I, and I want to go back to this question. I don't think you answered, and I want to put in context what it states. Answer it. I mean, you understand that we always presume statute to be constitutional, and is that unless